Hello everyone. It is known that the law is dynamic. It keeps on changing according to the times and changing needs of the society. Even the judicial interpretation also changes from time to time depending on various factors. Till now, you must have understood the position of women in India under various laws and in respect of different aspects of their life. We have attempted to throw light on areas like the constitution, personal matters including marriage, maintenance and divorce, property rights of women, sexual harassment at workplace, their reproductive rights and violence against women. In this lecture, we shall try to analyze the latest developments in the field of women and law with reference to legislative changes and judicial interpretation in the following areas already covered. First, let us have a look at the proposed changes regarding the marriageable age of women in India. The Prohibition of Child Marriage Amendment Bill 2021 introduced in Lok Sabha on 21st December 2021 proposes to change the age of marriage for girls by enhancing it to 21 years. This bill seeks to raise the age of legal marriage for women from 18 to 21 years and will apply to all communities in the country, and once enacted will supersede existing marriage and personal laws. Introduced in Lok Sabha by Mrs. Smriti Irani, Union Minister for Women and Child Development, the bill, which proposes amendments to the 2006 law, was sent to a parliamentary standing committee for further discussion. The minister said that the proposed legislation was secular. All women from all faiths under Hindu Marriage Act or the Muslim Personal Law or even the other laws relating to Christians should get equal rights to marry. The bill states in section 1 of the Prohibition of Child Marriage Act 2006, in subsection 2, after the words citizen of India, without and beyond India, the words, figures and brackets, notwithstanding anything contrary or inconsistent therewith contained in the Christian Marriage Act 1872, the Parsi Marriage and Divorce Act 1936, the Muslim Personal Law Shariat Application Act 1937, the Special Marriage Act 1954, the Hindu Marriage Act 1955 and the Foreign Marriage Act 1969 or any other custom or usage or practice in relation to marriage under any other law for the time being in force shall be inserted. Mrs. Irani, while stating that she understands the social, cultural, familial and sentimental issues associated with this decision, proposed on behalf of the government that this be discussed in detail in the standing committee. She therefore requested that the bill be sent to the standing committee. This bill certainly fulfills the spirit of the Constitution, as its provisions shall apply to all communities irrespective of any law, custom, usage or practice governing the parties, as the bill mentions therein. The central government deserves compliments for bringing in legislation to raise the age of marriage for girls from 18 to 21 years. It is perceived as a revolutionary measure to empower women by providing them enough time to complete education and build a career. Earlier, the opposition members, while criticizing the government for the haste in introducing the bill, said it was a violation of fundamental rights and would impact personal laws. Now coming to matrimonial causes, there have been certain developments. Under the Hindu law, divorce was unknown to the Shastric Hindu law, but this remedy is available under the Hindu Marriage Act 1955. The grounds for divorce available to both the husband and wife are outlined in section 13 clause 1 and clause 1A of the Hindu Marriage Act 1955. Recently, section 13 clause 1 and subclause 4 was omitted via the Personal Laws Amendment Act 2019 with effect from 1st March 2019 to remove leprosy as a ground for divorce. In other words, either spouse cannot use this ground for approaching a court for the purpose of divorce. Under Muslim law, a valid Muslim marriage is dissolved upon the death of the husband or the wife. On death of wife, the husband can marry immediately, but in the case of death of husband, the wife can marry only after the completion of iddat, that is the waiting period. A Muslim male may divorce his wife by uttering triple talaq at any time without assigning any reason or judicial intervention. However, a Muslim wife does not have a similar right of talaq. Therefore, Muslim women live with a perpetual fear of triple talaq. The unapproved form of triple talaq, that is talaq ul biddat, which means pronouncing talaq by husband instantaneously 3 times without giving any scope for reconciliation, was struck down as unconstitutional in Shaira Banu versus Union of India by the Supreme Court recently. Subsequently, the Muslim Women Protection of Rights on Marriage Act 2019 was brought into force from 19th September 2018 to make triple talaq illegal, declaring triple talaq in any form as illegal and void, whether spoken or written or by any electronic means, and imposed an imprisonment up to 3 years on the husband. It is well known that the Muslim woman can repudiate her marriage and get a divorce from her husband by talaq e tafweez or khula or zihar or lian or fasakh or under the Dissolution of Muslim Marriage Act 1939. Section 2 clause 6 of this act has been omitted by the Personal Laws Amendment Act 2019 with effect from 1st March 2019. Consequently, leprosy is now not a ground for divorce under the Act of 1939 applicable to Muslims. A similar change has been made under the Christian law, under which any spouse can file an application for divorce on the grounds enumerated in section 10 of the Indian Divorce Act 1869. While section 10 clause 1 of the act provides grounds of divorce that can be invoked by either husband or wife, section 10 clause 2 lays down the grounds that can be invoked only by the wife. Section 10 clause 1 subclause 4 of the above act was omitted by the Personal Laws Amendment Act 2019 with effect from 1st March 2019. Now, leprosy is not a ground for divorce. With regard to civil or registered marriages, section 27 clause 1 subclause G of the Special Marriage Act 1954 was omitted by the Personal Laws Amendment Act 2019 with effect from 1st March 2019. Consequently, leprosy is not a ground for divorce under the Act of 2019. Now, coming to maintenance of women. Under the Hindu Adoptions and Maintenance Act of 1956, wife can claim maintenance while the marriage is still subsisting. Not only the wife, even a widowed daughter-in-law, as long as she does not remarry, the children, unmarried daughter, widow, as long as she does not remarry, and mother are entitled to maintenance under this act. A wife is entitled to live separately from her husband without forfeiting her right to claim maintenance on certain grounds like adultery, cruelty, etc. But her unchastity, her conversion into another religion disentitles her to this right. Recently, Section 18, Clause 2, Subclause C of the Hindu Adoptions and Maintenance Act 1956 has been omitted by the Personal Laws Amendment Act of 2019 with effect from 1st March 2019. Leprosy is not a ground under the said provision to deny maintenance anymore. Another very important area which underwent certain changes has been the right to property of the Hindu women. The Supreme Court earlier in Prakash versus Pulavati case in 2015 held that the daughter is allotted such equal share only if both the father and daughter are alive on the date of the commencement of the 2005 amendment to the Hindu Succession Act 1956. The effect is that no distributions of such properties of persons or the common ancestor in Hindu coparcenary who passed away prior to the Amendment Act 2005 can be reopened or questioned by daughters. This judgment now stands overruled by the Supreme Court judgment in Vinita Sharma versus Rakesh Sharma case. Due to this judgment, the Hindu daughters can still claim their share in coparcenary even when such coparcener passed away before the commencement of the 2005 amendment. However, a daughter still has limited rights to ancestral property. A will can deny a daughter all rights to parental property. If a Hindu male does not make a will covering his share of the coparcenary property, upon his death, his share will devolve according to Section 8 of the Act of 1956. The apex court in the aforementioned Vinita Sharma versus Rakesh Sharma case held that daughters would hold equal coparcenary rights in Hindu undivided family properties even if they were born before the 2005 amendment to the Hindu Succession Act 1956. Now, coming to women and criminal law, it is known that after the horrific incident of gang rape in Delhi on 16th December 2012, Justice Verma's committee was set up to make recommendations on amending the various laws to provide for speedy justice and enhanced punishment for offenders in cases of sexual assault of extreme nature. Considering the report, Criminal Law Amendment Act 2013 was passed. Sections 375, 376, 376A to D are substituted by new sections 375, 376 and sections 376A to E. Earlier, the offence of rape was a gender neutral offence. Now, this offence is gender centric and is enlarged in scope. New offences have been created and stiffer punishment has been suggested to those committing it, such as leaving the victim in a vegetative state, intercourse by a man with his wife during separation, custodial rape, gang rape and repeat offenders. The IPC differentiates between rape within marriage and outside marriage. Recently, the Criminal Law Amendment Act 2018 with effect from 21/4/2018 inserted new sections, namely section 376AB dealing with rape of a woman under 12 years of age, 376DA which deals with rape of a woman under 16 years of age and 376DB dealing with gang rape on a woman under 12 years of age have been inserted. A slow but certain change seems to have commenced in the area of marital rape, though the accepted and legal position is that A husband would not only be guilty of rape even if he forces himself sexually upon his wife without her consent. In Independent Thought versus Union of India, the Apex Court's division bench held that sexual intercourse with a girl below the age of 18 years is rape irrespective of whether she is married or not, and exception 2 of section 375 of Indian Penal Code is violative of the rights to equality and non-discrimination. It held that this classification of married girl child violates the right to life of those between 15 and 18 years of age. This case arose under the Protection of Children from Sexual Offences Act 2012, popularly called POCSO Act. Most often, women are victims of matrimonial cruelty. IPC provides many matrimonial protections under sections 493 to 498 and 498A of the Indian Penal Code. Recently, in a significant development, adultery was decriminalized in India on 27th September 2018, when the Supreme Court struck down section 497 of Indian Penal Code as unconstitutional. However, it continues to be a ground for divorce under the Hindu Marriage Act 1955. The constitutionality of section 497 was challenged before the Supreme Court in Joseph Shine versus Union of India in the year 2018, and the provision was struck down as unconstitutional. Coming to the Women and Employment Law, it is noticed that in lower income jobs, the Employee State Insurance Act or ESI Act is a comprehensive self-financing social security and health insurance scheme for workers. The Act extends the benefits to the employees drawing wages not more than rupees 15,000 per month, including the contract labor. With effect from 1st January 2017, the wage limit for coverage under the ESI Act is enhanced from rupees 15,000 to rupees 21,000. On April 1, 2017, the Maternity Benefit Amendment Act 2017 came into force, amending major elements of the Maternity Benefit Act 1961. The key provisions brought in by the amended Act enhance the maternity leave period, besides introducing several compliances for companies. Some of them are increasing the maternity benefit from 12 weeks to 26 weeks for 2 surviving children and 12 weeks for more than 2 children. Then 12 weeks maternity benefit to a commissioning mother and adopting mother in case of surrogacy and adoption respectively. Third one is flexibility to work from home, and the fourth one is mandatory provision of creche facility in respect of establishment having 50 or more employees. These changes have been justified on the ground that the maternal care to the child during early childhood is crucial for growth and development of the child. Now coming to sexual harassment of women at workplace. India's first legislation specifically addressing the issue of workplace sexual harassment, namely the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, well known as the POSH Act, was enacted by the Ministry of Women and Child Development in India in 2013. The government also subsequently notified the rules under the POSH Act titled the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Rules 2013. They may be called POSH rules. The year 2013 also witnessed the Criminal Law Amendment Act 2013, which has criminalized offences such as sexual harassment, stalking and voyeurism under section 354A to 354D of the Indian Penal Code. The POSH Act has been enacted with the objective of preventing and protecting women against workplace sexual harassment and to ensure effective redressal. The statement of objects and reasons of the Act denotes and explains that complaints of sexual harassment have to be entertained by the Internal Complaints Committee. While the statute aims at providing every woman, irrespective of her age or employment status, a safe, secure and dignified working environment free from all forms of harassment, proper implementation of the provisions of the statute remains a challenge. Justice Pushpa Ganediwala of the Nagpur bench of the Bombay High Court, in a judgment passed on January 19, 2021, held that there must be skin-to-skin contact with sexual intent for an act to be considered sexual assault. She said in her verdict that mere groping will not fall under the definition of sexual assault. This judgment, delivered under the POCSO Act of 2012, was overruled by the Supreme Court subsequently. Coming to the reproductive rights of the women, in a boost to the rights of the mothers who want to terminate their pregnancy due to several reasons, the upper gestation limit for the fetus to be aborted was enhanced from 20 weeks to 24 weeks for special categories of women via the Medical Termination of Pregnancy Amendment Act 2021. The amended provision was brought into force from 25th March 2021. With regard to dowry and domestic violence, with the realization that the law outlined in Indian Penal Code only covers limited portions of domestic violence challenges faced by the women, the Protection of Women from Domestic Violence Act 2005 was enacted with a view to provide for more effective protection of rights of women who are victims of violence of any kind occurring within the family. Under section 17, every woman in a domestic relationship shall have the right to reside in the shared household, and she shall not be evicted from the shared household except through legal process. The Supreme Court in Satish Chandra Ahuja versus Sneha Ahuja, decided in the year 2020, overruled its earlier view held in S.R. Batra versus Tarun Batra in 2007. Now, the wife can claim right of residence in the shared household may either be owned or tenanted by the husband singly or jointly. However, in M. Ramachandra Warrior versus Jayashree case, decided on 18th day of March 2021, a 2-judges bench of the Kerala High Court held that a divorced wife would not be entitled to the right of residence conferred under this section 17. She can be evicted only in accordance with law. This right of residence is available only to a woman in a domestic relationship. Now, about the Uniform Civil Code. In the evergreen saga of demand for a uniform civil code in India, as mandated under Article 44 of the Constitution, the Chancellor of Maulana Azad National Urdu University in Hyderabad, Mr. Firoz Bakht Ahmed, has moved the Supreme Court seeking a direction to the government to constitute a judicial commission or a high-level expert committee to prepare a draft of the Uniform Civil Code. Mr. Ahmed, who is also the grandnephew of the independent India's first education minister, Maulana Abul Kalam Azad, said that the draft should be drawn in keeping with the constitutional rights and international conventions to secure gender justice, equality and dignity of women. Uniform Civil Code calls for formulation of one law to be made applicable to all religious communities in matters such as marriage, divorce, inheritance and adoption. The PIL has been filed to weed out anomalies in minimum age of marriage, grounds of divorce maintenance, alimony, adoption, guardianship, succession, inheritance based patriarchal stereotypes which perpetrate inequality against women and go against global trends, the petition said. The matter is sub judice now. Now, we look at international efforts for women empowerment. We find that a report entitled Empowering Women at Work, Government Laws and Policies for Gender Equality, published by the International Labour Organization in 2021, has thrown many new issues to be discussed, debated and implemented. The report emphatically states that no country has so far achieved gender equality, not even among the highest economic countries in the group of 7, that is G7. This document examined how governments can design and implement policies that promote a future of work that is gender responsive by design and is anchored in social justice and decent work principles. It focuses on 5 key areas where government policies can reverse the regressive effect of the crisis and revitalize progress towards the sustainable development goals. Achieving equal pay for work of equal value, preventing and eliminating violence and harassment in the world of work, creating a harmonious work-life balance for both women and men, promoting women's equal representation in leadership in the world of work, and investing in a future of work that works for women. The report concludes that achieving gender equality during this turbulent time and building back a better future for all women is not only feasible, but it is also an imperative. Governments and other stakeholders in the world of work have the knowledge and the resources required to succeed. It is time to take action now, the report says. Now, coming to the conclusion. A survey of some of the significant legislative changes and judgments shows that the position of the women in India is improving socially, economically and politically, at least to some extent. Certain controversies relating to the so-called love jihadis, entry of women into places of worship on par with men, same-sex marriages, and last but not the least, the hijab restrictions in public places would certainly engage the attention of the society in the near future. While the vested interests may play their role to the hilt, the women of India, irrespective of the caste, creed and religion, are reasonably expected to defend and protect their status and rights effectively. Let the equality of women be not only legal, but also real. I hope that you have enjoyed this lesson and updated yourself on all the latest developments in the field of women and Indian law.